What is forum non conveniens? The legal term forum non conveniens is derived from the Latin for inconvenient forum, being a common law doctrine that enables a court to stay a civil case, even though the venue is proper and the court has jurisdiction over the case and the litigants, where an appropriate and more convenient alternative forum exists in which to litigate the case. One of the litigants must raise forum non conveniens for the court to consider it. To understand the legal concept of forum non conveniens, one would be well served to read the words of Supreme Court Justice LeBel in the Supreme Court of Canada decision in Club Resorts Ltd versus Breda, where he succinctly and comprehensively analyzed this important legal concept. Forum non conveniens comes into play when jurisdiction is established. It has no relevance to the jurisdiction analysis itself. Once jurisdiction is established, if the defendant does not raise further objections, the litigation proceeds before the court of the forum. The court cannot decline to exercise its jurisdiction unless the defendant invokes forum non conveniens. The decision to raise the doctrine rests with the parties, not with the court seized of the claim. If a defendant raises an issue of forum non conveniens, the burden is on him or her to show why the court should decline to exercise its jurisdiction and displace the forum chosen by the plaintiff. The defendant must identify another forum that has an appropriate connection under the conflict's rules, and that should be allowed to dispose of the action. The defendant must show, using the same analytical approach the court followed to establish the existence of a real and substantial connection with the local forum, what connections this alternative forum has with the subject matter of the litigation. Finally, the party asking for a stay on the basis of forum non conveniens must demonstrate why the proposed alternative forum should be preferred and considered to be more appropriate. The court reviewed and structured the method of application of the doctrine of forum non conveniens in Amchem. It built on the existing jurisprudence and in particular on the judgment of the House of Lords in Spiliada Maritime Corp versus Cansulex Ltd. The doctrine tempers the consequences of a strict application of the rules governing the assumption of jurisdiction, as those rules are, at their core, based on establishing the existence of objective factual connections. Their use by the courts might give rise to concerns about the potential rigidity and lack of consideration for the actual circumstances of the parties. When it is invoked, the doctrine of forum non conveniens requires a court to go beyond a strict application of the test governing the recognition and assumption of jurisdiction. It is based on a recognition that a common law court retains a residual power to decline to exercise its jurisdiction in appropriate but limited circumstances in order to assure fairness to the parties and the efficient resolution of the dispute. The court can stay proceedings brought before it on the basis of the doctrine. A party applying for a stay on the basis of forum non conveniens may raise diverse facts, considerations, and concerns. Despite some legislative attempts to draw up exhaustive lists, I doubt that it will ever be possible to do so. In essence, the doctrine focuses on the context of the individual cases, and its purpose is to ensure that both parties are treated fairly and that the process for resolving their litigation is efficient. For example, Section 11, Sub 1 of the CJPTA provides that a court may decline to exercise its jurisdiction if, after considering the interests of the parties to a proceeding and the ends of justice, it finds that a court of another state is a more appropriate forum to hear the case. Section 11, Sub 2 then provides that the court must consider the circumstances relevant to proceeding. To illustrate those circumstances, it contains a non-exhaustive list of factors. A. The comparative convenience and expense for the parties to the proceeding and for their witnesses in litigating in the court or in any alternative forum. B. the law to be applied to issues in the proceeding. C. The desirability of avoiding multiplicity of legal proceedings. D. The desirability of avoiding conflict in decisions in different courts. E. The enforcement of an eventual judgment. And F. The fair and efficient working of the Canadian legal system as a whole. British Columbia's Court Jurisdiction and Proceedings Transfer Act, which is based on the CGPTA, contains an identical provision, Section 11, on Forum Non Conveniens. In Tech Cummco Metals Limited versus Lloyd's Underwriters, this court stated that Section 11 of the British Columbia Statute was intended to codify Forum Non Conveniens. Article 3135 of the Civil Code of Quebec provides that Forum Non Conveniens forms part of the private international law of Quebec, but it does not contain a description of the factors that are to be govern the application of the doctrine in Quebec law. The courts are left with the tasks of developing an approach to applying it and of identifying the relevant considerations. Quebec's courts have adopted an approach that, although basically identical to that of the common law courts, is subject to the indication of Article 3135 that Forum Non Conveniens is an exceptional recourse. A good example of this can be found in the judgment of the Quebec Court of Appeals in Oppenheim Forfait GmbH versus Lexus Maritime Inc., in which an action brought in Quebec was stayed in favor of a German court on the basis of Forum Non Conveniens. Justice of Appeal Pigeon emphasized the wide range and contextual nature of a Forum Non Conveniens analysis. The judge might consider such factors as the domicile of the parties, the locations of witnesses, and of pieces of evidence, parallel proceedings, juridical advantage, the interests of both parties, and the interests of justice. Regarding the burden imposed on a party asking for a stay on the basis of Forum Non Conveniens, the courts have held that the party must show that the alternative form is clearly more appropriate. The expression clearly more appropriate is well established. It was used in Spiliada and Amchem. On the other hand, it has not always been used consistently and does not appear in the CGPTA or any of the statutes based on the CGPTA, which simply require the party moving for a stay establish that there is a more appropriate form elsewhere. Nor is this expression found in Article 3135 of the Civil Code of Quebec, which refers instead to the exceptional nature of the power conferred on a Quebec authority to decline jurisdiction. It may exceptionally, and on an application by a party, decline jurisdiction. The use of the words clearly and exceptionally should be interpreted as an acknowledgement that the normal state of affairs is that jurisdiction should be exercised once it is properly assumed. The burden is on a party who seeks to depart from this normal state of affairs to show that, in light of the characteristics of the alternative form, it would be fairer and more efficient to do so, and the plaintiff should be denied the benefits of his or her decision to select a form that is appropriate under the conflicts rules. The court should not exercise its jurisdiction in favor of stay solely because it finds, once all relevant concerns and factors are weighed, that comparable forms exist in other provinces or states. It is not a matter of flipping a coin. A court hearing an application for a stay of proceedings must find that the form exists that is in a better position to dispose fairly and efficiently of the litigation. But the court must be mindful that jurisdiction may sometimes be established on a rather low threshold under the conflicts rules. Forum Non Conveniens may play an important role in identifying a form that is clearly more appropriate for disposing of the litigation, and thus ensuring fairness to the parties and a more efficient process for resolving their dispute. As I mentioned above, the factors that a court may consider in deciding whether to apply Forum Non Conveniens may vary depending on the context, and might include the locations of parties and witnesses, the cost of transferring the case to another jurisdiction, or of declining the stay, the impact of a transfer on the conduct of the litigation, or on related or parallel proceedings, the possibility of conflicting judgments, problems related to the recognition and enforcement of judgments, and the relative strengths of the connections of the two parties. Loss of judicial advantage is a difficulty that could arise should the action be stayed in favor of a court of another province or country. This difficulty is aggravated by the possible conflation of two different issues: the impact of the procedural rules governing the conduct of the trial, and the proper substantive law for the legal situation, that is, in the context of these two appeals, the proper law of the tort. In considering the question of judicial advantage, a court may be too quick to assume that the proper law naturally flows from the assumption of jurisdiction. However, the governing law of the tort is not necessarily the domestic law of the forum. This may be so in many cases, but not always. In any event, if parties plead the foreign law, the court may well need to consider the issue and determine whether it should apply that law once it is proven. Even if the jurisdictional advantage leads to the conclusion that courts in different states might properly entertain an action, the same substantive law may apply, at least in theory, wherever the case is heard. A further issue that does not arise in these appeals is whether it is legitimate to use this factor of loss of judicial advantage within the Canadian Federation. To use it too extensively in the Forum Non Conveniens analysis might be inconsistent with the spirit and intent of Morgard and Hunt, as the court sought in those cases to establish comity and a strong attitude of respect in relations between the different provinces, courts, and legal systems of Canada. Differences should not be viewed instinctively as signs of disadvantage or inferiority. This factor obviously becomes more relevant where foreign countries are involved. But even then, comity and an attitude of respect for the courts and legal systems of other countries, many of which have the same basic values as us, may be in order. In the end, the court must engage in a contextual analysis, but refrain from leaning too instinctively in favor of its own jurisdiction. At this point, the decision falls within the reasoned discretion of the trial court. The exercise of discretion will be entitled to deference from higher courts, absent an error of law or a clear and serious error in the determination of relevant facts, which, as I emphasize above, takes place at an interlocutory or preliminary stage. I will now consider whether the Ontario courts properly assume jurisdiction in these cases, and if so, whether they should have declined to exercise it on the basis of foreign non-convenience. Thank you.